misread the case number. It's DC 2102003, just so the record's clear.
I apologize. Okay, let's proceed.
Thank you, Your Honor. This, I hope, will be a short hearing. This is an application for a foreign deposition arising out of an arbitration. This is a FINRA arbitration with three arbitrator panels. It's for the deposition of Orion Sullivan. It's a third-party witness who resides in California. Mr. Sullivan's counsel is not at this hearing. The party objecting to this application is actually the respondent in the arbitration. So my client, Mr. Barnes, is the claimant in the FINRA arbitration. Credit Suisse is the respondent. That's who Mr. Ellis represents. The factual background of the arbitration is really not that important. I won't really go into it that much. This is really a procedural process. In actuality, it's a pro forma process. I'm somewhat surprised we're actually here for hearings. So I hope it's short. On two occasions, the full three-person FINRA panel had hearings and ordered this deposition of this third party, Mr. Sullivan, in California. Again, on two occasions, overruling Credit Suisse's objections. The panel knew that Mr. Sullivan was in California. They ordered the deposition. They ordered the deposition in California. As Your Honor knows, under the foreign deposition rules and sort of the letters rogatory rules under 201, and when you couple that with the TAA regarding arbitration, the court's role really is as an extension of the FINRA panel, of the arbitrators. Because obviously the arbitrators, while Credit Suisse and my client are subject to their power, as to third parties, an arbitral forum like FINRA needs Your Honor to, in essence, bless a subpoena or an order and then send it out of state. And that's where we are here. So we have the TAA, the Texas Arbitration Act, which allows for subpoenas and depositions specifically. We have TRCP 201, which deals with letters rogatory, where we need to get some discovery that's not in Texas and we got to go out of state. Then there's the California statute, which allows for foreign subpoenas and orders, which in essence, I take an order from Your Honor, which essentially summarizes an order from an arbitration panel. I can give it to a lawyer in California. That lawyer in California then can create a California subpoena, which I then serve on Mr. Sullivan, and he then is bound to give this deposition testimony. So it's a multi-step process. Again, first step was going to the FINRA arbitration panel. And I think Mr. Ellis will agree on this, two very heated, widely contested hearings. That arbitration panel on two occasions said, yes, you get his deposition. That order has been submitted to the court with our application from that FINRA panel. TAA allows for this depositions and subpoenas. Really the objection made by Credit Suisse, and I want to note, the actual deponent, Mr. Sullivan, is not at this hearing. This is the respondent who is trying to prevent this discovery ordered by the FINRA panel. And if Mr. Sullivan has any objections, obviously he can make those objections in California. Really the objection made by Mr. Ellis is as to Rule 176 regarding subpoenas. And Mr. Ellis says, well, Rule 176, you have to serve it in Texas. Well, of course I can't serve it in Texas. Mr. Sullivan lives in California. That's the whole purpose of Rule 201 regarding letters rogatory. That's the very purpose. And if you actually read Rule 176, it states it's not a prevention of an issuance of a subpoena. It says you can't serve it on Mr. Sullivan. Well, we're not serving anything on Mr. Sullivan. What happens is I take that order and subpoena and I go to a lawyer in California. That lawyer in California under the California, let me get the exact statute for you, California Interstate Discovery Act, can then, like a lawyer in Texas, issue a subpoena under his signature, California lawyer signature, and then give it to Mr. Sullivan. It's then valid. So no Texas subpoena is going to ever be served on Mr. Sullivan, period. So the objections by Mr. Ellis under Rule 176, A, just don't apply. B, are nonsensical, because if Mr. Ellis's theory prevailed, we could never get out-of-state discovery. Because the party would always argue, well, under this Rule 176, you have to serve it in Texas. They don't live in Texas. And that's not the way it works, as I'm sure Your Honor knows.
Okay. Mr. Ellis?
Yeah, Judge, I want to be very clear. My objection is in this hearing is to the procedure. He's asked for a subpoena. There's no contention by my party, by my client, that the arbitration panel didn't do what it did. Mr. Iacone is correct. There were these contentious hearings. We have an order from the arbitral body. There's no issue with that. My issue is simply with the procedure. And, I filed a 3-page saying, look, the Texas court, and I want to make sure Mr. Iacone gets this right? I mean, that's all I'm asking, is that I don't think that the Texas court can issue a Texas subpoena whereby the Texas court is asking or commanding a constable within the state of Texas to serve a Texas subpoena on a non-Texas resident. So therein lies my problem. It's not now, if Mr. Iacone had asked, which his reply suggests that his original request in fact did ask, but it didn't. If he had asked the court to issue some sort of an order, and he had provided a order that he would then present to a foreign jurisdiction requesting, similar to a letters rogatory, right? Asking the foreign court to go ahead and issue a subpoena, fine. That's different than asking this court to issue a subpoena to a Texas constable to be served in Texas. Now, because that's not actually, as Mr. Iacone correctly stated, that's not actually what's going to happen. So essentially, in my mind, what Mr. Iacone is asking you to do is prepare a Texas subpoena that where you, the judge or the court, commands a Texas constable to go ahead and serve a Texas subpoena, where in fact that's not actually what's going to happen. And so that's my rub, Judge. I'm not trying to gunk up the wheels here. All I'm trying to do is make sure that the procedure is done correctly. And I think Mr. Iacone's reply says it all. And that is the last line or so says, essentially, Judge, I don't know exactly what you're supposed to issue, but issue whatever you're supposed to issue so that I get this right, whether it be an order or a subpoena. And again, I just want to make sure that this procedure happens correctly. I'm not trying to gunk up anything. But I don't think it's the right procedure for you, Judge, to issue a subpoena that is never ultimate to a constable that is never ultimately going to commanding a constable to do something that constable will never end up doing because nobody's in Texas, or this Dr. Sullivan's not in Texas. So that's my only issue. I mean, if Mr. Iacone wants to circulate to me an order that he believes will be that he believes is going to be helpful, then I'm okay by that. But I don't think the issuance of a subpoena is the right way.
And if I may, Your Honor, very briefly.
Okay.
It's actually and I apologize. There's a corrected order. It's not corrected. It's attached to our reply. And it was a subsequent order submitted. So that might be the correct one. And the only difference is it's a different date, because in the FINRA panel's initial order, they said, well, we want this to try to be completed by March 22nd or 23rd. And they didn't issue that order till the end of January. We filed this at the beginning of February. We had ice storms. We tried to get it set as soon as possible. Your Honor's obviously very busy. So the only change we had in the proposed order and subpoena in the reply really is the new date. We wanted to give ourselves another month to be able to go to California in case Mr. Sullivan decides to object to it in California. That's really the only distinction there. And what I would say is, again, Mr. Ellis's objections are as to service. This subpoena will never be served on Mr. Sullivan. It's simply a mechanism.
So I'm trying to find the proposed order here. This is the reply. I don't see an order attached to it. Maybe there's a different order you're
It would have
talking
been
about?
filed at the same time. So whatever date that was, the reply, which I think, Your Honor, was Wednesday. If you see an order in a
Okay, it looks like there may be another one. Let me see if this is the correct one. Is this the correct one? April 29th?
Yes, Your Honor. That's the correct one. Yes, Your Honor. There's an order and then a subpoena as well.
Okay, so what exactly do you see as the issue with this, Mr. Ellis, just so I
Yeah.
kind of can address
So
your concern?
one example, Judge, is, it says further, it is.
Let
ordered-
me go ahead and share screen, so it's, okay, where?
So if you look at further, which is the first, second, third paragraph,
Mhm.
it says further, it is ordered that the subpoena attached as Exhibit 1 to this order is granted. I don't know what that means, that the court is granted, that a subpoena is granted. Now, maybe the issuance, I don't quite understand what that means, is that the subpoena is granted. And then the next line says, further, is it ordered that a duly licensed court reporter is hereby authorized to administer the oath to Ryan Sullivan in or near San Diego, California. My issue there, Judge, is that, with all due respect, I don't think you have the authority to authorize a court reporter, a California court reporter, to issue an oath to Mr. Sullivan, Dr. Sullivan, in San Diego, California. I just don't think you have the authority to do that. Now, like a letters rogatory would be, Judge, you request a court in California to issue an order such like this. And then the next line, further, it is ordered that such deposition be taken at this place in San Diego, California via Zoom webcast. Again, Judge, I don't think you have the authority to command a out-of-state resident to appear for a deposition. That is the province of the foreign court to do. Now, you can request, I believe, under the Texas rules, you can request that a California court do that. But how is that enforceable, Judge? For you to command a guy in California or any other state in outside of Texas to appear for deposition? I don't think you have that power. And that's what this order is asking you to do. And
the last paragraph.
And then finally, further, the court requests the assistance of a court of competent jurisdiction in San Diego in obtaining issuance of subpoenas. Now, that I think is fine. I think that part is fine. I just don't think that you can do any of these other things that he's asking you to do. That's just not within your jurisdiction. The last thing is that, look, you can ask a California court and he can present this to a California court.
You know, I have never heard anyone make this argument. It's kind of an interesting one, but I guess, for example, if we have a judgment in Texas, and somebody wants to execute on assets in Oregon, they can, I can't order that to occur, but the judge in Oregon can issue all of that. And so, and I've had situations and a number of times where a court, let's say, has issued an order in, issued an order in Ohio, and they want to take a deposition here in Texas and do discovery here in Texas, and they try to enforce that. The law, as I understand it, is that we go with the procedure of the state that, that where it's trying to be enforced, but the substantive law, I think, of the original jurisdiction, if I recall correctly. Anyway, bottom line is that I think the orders usually say, okay, we want the deposition to take place. We allow the following, and then I make a determination as the local judge. Okay, is that allowed under Texas law?
That's right.
But I don't know if this language is inappropriate or not. I do think there needs to be some direction to maybe we say further is ordered that such deposition shall be taken at blah, blah, blah via the Zoom webcast platform to the extent allowed by California law or something like that. Would that address your concern? Or
So I think, Judge, the way it needs to happen is that, and Mr. Iacone can put this in an order that you sign, that you, Judge, are requesting a foreign jurisdiction, Ohio, to use your example, to issue a subpoena, which is exactly what he asks in the last sentence. Further, the court requests the assistance of the court competent jurisdiction in California in obtaining the issuance of a subpoena. And so I think what you could do is have that same request and perhaps list in the request that these are the times that you request that a subpoena be issued for, and then the California or whichever court deals with this can then make the ruling. I just don't think that you can order a California citizen that is not under your jurisdiction to do anything, and that's what this order that they've proposed does. Now, you can ask a California court to go ahead and request, and because the California court has jurisdiction over that individual. That's our only gripe, is that, my suggestion, Judge, would be that the further order the court stays in, and that there be bullet points below the further order, your requests to the California court are the following, so that you request that the California court issue a subpoena for these following things, rather than you, Judge, signing an order that requires a foreign citizen to do something that this court.
Response?
Yeah, Your Honor. This took a lot of time, and the order is actually well thought out, and I'll explain why. The very first paragraph, which is our application, is under 171.086. So remember, there's two things going on. We're in arbitration. I have to, one, have Your Honor order a subpoena and deposition out of an arbitration, irrespective of California. So the first part is these ordered parts are, okay, under 171.086, I'm ordering that there can be a deposition, even though it's an arbitration, and I'm ordering there can be a subpoena, even though it's an arbitration. So that's your ordering granting.
That makes sense.
The
That makes sense.
TAA part. The last section is essentially the letters rogatory. And unfortunately, under California, it is a tweak, because I know Your Honor, Mr. Ellis, are familiar with the typical letters rogatory process. The California statute says it needs a foreign subpoena first before that you give to a California lawyer, who then issues a California subpoena. And that, Your Honor, is the California statute, and I can give you the exact code, 2.029.350A.
Okay, are you still there? Guys, are you there?
Yeah, we're
Yes,
here,
sir.
Judge.
Okay. You disappeared for a second. I'm just trying to print something out. So you keep going.
Yes, Your Honor. What I was saying is the tweak under California procedure is all states do it differently on what they need from a foreign jurisdiction to effectuate the subpoena request. And what the California statute says is that you first, and it's so we all can be there. If anyone wants to look, it's in our plea, in our reply and in our motion. It's 2.029.350A, and it basically says to get a subpoena in California from a foreign litigation, it needs that, and it uses a subpoena. For instance, here from Texas, and that's why we have the subpoena part. So, for instance, Your Honor, that's why we have two part. We have the order and we have the subpoena. So the order, the first section of the order is granting the TAA statute, which allows Your Honor to order a deposition and subpoena arising out of an arbitration. The last paragraph in the order is essentially a furtherance of a letters rogatory. Hey, please do what you can to do this. And then the attachment, the actual subpoena is the foreign subpoena that's required in California that I give to a California lawyer, not Mr. Sullivan, a California lawyer. So it's never served on Mr. Sullivan. And then that California lawyer, then under the statute, can issue his own subpoena that reflects essentially the deposition time, et cetera, et cetera.
Okay, I'll go ahead and grant the request. I mean, I understand the concern. I think this is okay. And
Judge, I respect your ruling. I just don't know how you would enforce, for instance, what happens if a California court reporter doesn't administer the oath? You have no authority to force her or him to do so.
I'm just authorizing her to do it. I'm not forcing her.
Okay. And what about the deposition shall be taken at, you're ordering a California or a foreign resident to sit for deposition at a certain time? I just, again, I just don't want to get into a situation where I have never seen a Texas judge order a out-of-state citizen to sit for a deposition. And so I just, how would you enforce that, for instance?
Through the California court. You're right, I couldn't enforce it. It'd be through the California court. That's why we have the last paragraph. Max, I can't get this printed from here. Can you ask Tony to go, or Rhonda to go print it? Do you have all the stuff that you need for it, the cost number and everything?
Oh, yeah.
Okay. All right, anything else, guys?
No, Your Honor.
we have,
Thank
Judge.
you.
Thank you.
You guys
Thank
have
you,
a
sir.
good day.
I hope you're
It's
safe.
good to see everyone.
Yes, sir. Bye.
Okay, I think our next case is Shelby v. Caldwell. Mr. Shelby, are you there?
Yes.
How are you today?
Oh, I'm hanging in here. How about yourself?
Same here. I think that's the best we could all do.
Mhm.
So I took a look at what you submitted. So kind of explain to me what's going on so I can try to figure out how we can get there.
Yes. I was hit on the freeway on I-30 here by a pickup truck with some kind of work equipment hanging over the side of it, and it forced me off the road. And there was a lot of traffic out there at night, and it was dangerous on the highway. So I took the license plate and the information that the driver gave me, but it turned out that it wasn't all there. And it left me in a loop. So I have property damage and personal injury. And I need some assistance from the sheriff, maybe the Tennessee Vehicle Service Division. They told me that I needed a court order from the judge to have the information I needed, which would be the owner's name and the owner's address and insurance policy, so we can serve them to come to court. So I need some assistance here.
Okay. Okay, so I'm looking at what you submitted.
I need to be able to serve the party. It seems that the address that the gentleman gave, he's not responding back.
Have you, I mean, I'm not, this isn't an order, it's just a question. Have you requested have you tried to get an attorney to help you with this?
Yes, and they couldn't go too far with it. It left me here to come in and try and get some assistance from this direction.
Okay. What you're basically wanting is the address of the individual who hit you, basically, based on the license plate number.
Right. So we can serve the proper party.
So you don't have an address through the driver's license?
That address is getting a return mail. I sent a certified letter to the gentleman, and it's getting a return mail from that address that was on the driver license.
Okay. All right, I'll sign an order. So to allow them to give you the address of that truck. There's some other stuff in the order. I'm not sure exactly what you wanted, but I will allow that. Nancy, can you grab me the order? I just put it out.
Okay.
Does
Yes.
that make sense?
Yes, we need the owner's name, address, so we can serve them. Yes. I had them trying to mail that out in the clerk's office, but we didn't get the response we was looking for, the petition to them.
Okay.
So
Well, I'll go ahead and do an order. You should be able to see it online by tomorrow, I would guess, or maybe the day after, but it should be tomorrow.
okay, thank you very much.
All right, you have a good day.
You too.
Mr. Smith, what are you here for?
Good afternoon, Your Honor. I'm here for the Berry matter. This is kind of an old one.
All right, so we have, yeah, it is old. All right, let me do this. I need to go grab a couple orders I just printed out, and I'll be back. This isn't scheduled to start until 4 o'clock, so I'll be back in a second.
Okay, that's fine. Thank you.
All right, Mr. Smith, are you there?
Yes, I'm here. Can you hear me?
I do. So do you work with Mr. Cronenwet?
Yes, he's at my firm.
Okay. All right, let's go on the record on cause number DC 1813084, U.S. Bank and Trust, N.A. versus Robert Berry. Counsel, make your appearance.
Hi, my name is Jonathan C. Smith, attorney for plaintiff.
Let's proceed.
Okay, so this is a motion to amend the order of sale. I know there's been, a couple of them before because we're trying to get this order of sale just right. The last time we used an order, we sent it to the constable, to execute, and he noticed that there was something wrong in the legal description. So basically all it is it says Walters and it should say Walkers.
That's the only change.
Yeah, that's the only change. And
That's kind of what I remembered. So, all right, so we'll just get that changed. All right, let me just. Did you submit a new order?
yes, I believe it was last year when we filed the motion to amend. Let me see
It
what the
looks
date
like there
was.
something submitted on March 10th. Is that something different?
Yeah, March 10th. Yes, that's when it was. March 10th of 2020.
Where does it give the legal description?
The corrected one.
I just want to make sure I'm signing the correct order.
I believe it should have been attached to the one. Oh,
Is this the correct one?
let's see. If you scroll down, I'll look at the legal description and make sure.
Oh, it's under Exhibit A. Is that it? Is this it?
That's correct. So it should say Walker and Walkers. Yeah, that's the correct one.
It should say Walker and Bose.
Yeah, it should say Walker and Bose instead of the old Walters. Walter and Walters. It's really confusing.
Totally understandable. All right, I'll go ahead and sign that. Anything else that we need to discuss?
I think that's all, Your Honor.
I just printed out the order, Max, sorry. Okay. Have a good day, Mr. Smith, and you be safe out there, okay?
All right, thank you. You too, Your Honor.
Thank you.
Bye-bye.
Bye-bye.